Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story, we turn our attention once again to the Treehouse murder trials of Florida. Franklin Tucker was accused of being one of the assistants related to this murder, and he was recently on trial and came to a mistrial. And apparently the vote was 11-1 to convict. He represented himself acting pro se, and the state's case was extremely thin at best. They had basically a one witness case, one of his co-conspirators who said that he was involved, but had really no other evidence outside his co-conspirators to convict him. And the state tried to convince us that this witness was reliable using buttressing testimony, but they had no corroboration in a technical sense. They had no information that existed outside the co-conspirator that could be used to tie him to the murders. And also one of the victims themselves said that he was not the one who was involved. And apparently, despite all this, we had 11-1 to convict. So I think it goes to show a couple of important lessons. It shows how much people think that because you're sitting at the defense table, you must be guilty. And it goes to show that even with a very, very weak case, that the defense has an obligation to show the weaknesses in the case. If you don't have someone actively pointing out the weaknesses in the case at best, and preferably presenting evidence of your own, then you're all but doomed. And should he choose to represent himself again, I think that he has a very serious problem. So I hope he'll learn from his lesson, but it doesn't seem likely based on this article. So let's turn our attention to this article from the Key West Citizen. The state is seeking to retry in the Treehouse murder case, which, if they had 11-1 to convict, I'd probably be thinking about that too. The state prosecutors have indicated that they will retry the suspect, Franklin Tucker, in the 2017 murder of Matthew Bonnet and the robbery and assault of Paul Belmont, after the jury apparently voted 11-1 to convict him of the crimes. I believe it was Robert Barnes who said that we can talk all about what we can talk all we want about proof beyond a reasonable doubt, but in the real world, juries vote by preponderance. If they think it's more likely than not that you did it, they're going to vote to convict. And I think this is sort of emblematic. I don't even really think it's more likely than not that he did it. I just don't think that we even reached that threshold. We are barely above probable cause as I'm trying to assess out the relevant factors. But without an attorney to point out the weaknesses, without an attorney to really drum the points home in a coherent way, which is Mr. Tucker's weakness, that he tends to ramble and not present things in a linear and coherent fashion. Without the ability to present that and really highlight that and really bring those points home, the jury never hears about it. So, if you're sitting at the defense table, you're already one step in to getting convicted. And I think this is emblematic of that in the real world. The lack of consensus among juries is generally called a hung jury. I'm not sure what else we would call it, but okay, generally. After a jury could not reach a unanimous decision, the judge then gave the jury what's called an Allen charge and ordered the members back to further deliberation to see if they could reach a unanimous decision. So the judge is allowed to try once from this case called Allen to basically send them back. And I did apparently misspeak earlier, so I do have to correct myself from an earlier stream. Someone brought to my attention a Court of Appeals case from Florida, which said that if the judge just merely sends the jury home to come back the next day after an Allen charge and after them still saying that they can't make a decision, it is apparently not a constitutional violation. So I was wrong, apparently, as it applies to Florida precedent on this issue. So it's also a cautionary tale to me as a lawyer to perhaps be less certain on things, because states continue to surprise me. Because on a prior stream, I had said, oh, this is just flatly unconstitutional. After an Allen charge, if they come back and they're like, we're still not done, it's like, what do you mean you want to send them home? You can't do that. That's illegal. But apparently the Court of Appeals of Florida disagrees with me. So, okay. So, it's one of the cautionary tales to me as a lawyer to perhaps be less certain in things I say. It's one of the reasons that lawyers get caught up in this it depends thing so much, that so many of you guys hate when the lawyers do it depends, because, well, we constantly get surprised about what the law is, especially when we're not speaking about something we know really, really well. For example, the finer points of jury charges when it comes to Florida law. So I do have to correct myself. Apparently, the judge could have sent the jury home for the night, but chose not to do that. The jury deliberated again and could not reach unanimous consensus, so then the judge then declared a mistrial. The jury deliberated for roughly 6 hours before sending the jury note saying they could not reach unanimous decision, and then I think it was about a half hour after they're like, yeah, we can't do it. Now, Mr. Tucker apparently questions whether the jury really voted 11-1 to convict, which is not a positive sign. It is not a positive sign. He doesn't want to believe it. And also, as I sort of pointed out before, it kind of doesn't matter in some ways, because the ice cream murder trials, there was a double murder in Florida that was known as the ice cream murders because it involved an ice cream truck, or a guy who owned an ice cream truck at least. So there was known as an ice cream murder trials. Okay, double murder. There was an initial trial in which the jury came back 11-1 to acquit, 11-1 not guilty. And in the subsequent trial, 12-0 guilty. So, first of all, the fact that he doesn't believe it is scary to me. He is so wrapped up, perhaps, in his own wish fulfillment that he's unwilling to believe it. And second of all, even if he did believe it, it doesn't matter. Like even if he thought it was literally 11-1 the other way around, and I tried to tell him this during our stream with him. I tried to tell him this. I brought up this exact example to him. Hopefully he heard me. But I'm like, yeah, even if it was 11-1 to acquit, that is no guarantee to the future. So, yeah. So, first of all, the fact he doesn't believe it is not really great. And even if he believed it was something else, it really shouldn't matter. But okay. So Tucker over here, the defendant, questions whether or not it's really 11-1, which, I'd kind of take it at face value if no other reason than self-preservation, but okay. Mr. Tucker, the defendant, saying, I will consider this a win after the judge declared a mistrial. I didn't put on the case I want to. I learned from my mistakes. So did the prosecutor, by the way. The case is not going to get better for them. The facts are the facts. Well, it might get better for them because they might be able to do different things the second time around. And Mr. Tucker has talked about different witnesses coming in this time because he wasn't allowed to call them this time, apparently. But somehow he thinks the judge will allow him to call him in the next time, which could be true. The judge could make a different decision. But why would he? Unless you present an argument why he was wrong the first time. So Mr. Tucker, I think, is perhaps not willing to accept the reality of the situation in front of him, perhaps to his own detriment. So I'm worried about that. The Monroe County Sheriff Office deputies arrested Tucker, Mr. Wilson, and Mr. Travis Johnson, who is basically the only witness against Mr. Tucker in the end. It was Travis who took a deal. He was facing life himself and took a deal. How about 5 years instead of life? That's a pretty good deal. And as part of that deal implicated Mr. Tucker. So what's his incentive to lie? I don't know. How about the 5 years instead of the life? Is a pretty good incentive to lie. It's like, I got to give you someone else to get this deal. So who's available? Yeah. If found guilty, Tucker, of course, faces life in prison. The state's attorney's office has already begun preparations for the retrial, with the first hearing scheduled for March 7th, said the prosecutors, which was what the judge initially said as well. The prosecutor's office, for their part, saying, my office remains dedicated to upholding justice, and ensuring the legal process is conducted with the highest standard of ethics, fairness, and integrity. Not really sure about that one, given some of the things that happened at the trial, but, whatever. This case is of great importance, not only because of the crime's serious nature, but also due to the impact on the victims, their families, and our community. Our community is seeking justice for Matthew Bonnet and Paula Belmont remains unwavering. Well, I appreciate your seeking justice. That's always good. But prosecutors, of course, by rules of ethics, are supposed to seek justice, not convictions. And apparently they thought these are the same thing. Because I'm not even sure how the prosecutor believes they have enough evidence to bring this this trial. Because you have the completely uncorroborated statement of one co-conspirator. The prosecutor used the word corroboration a lot, but they used the word wrong. And again, a lawyer would have been able to bring this point home. So, for example, the prosecutor said that Tucker's statement, apologize, Travis, I always get the names confused. Travis's statement was corroborated because, for example, he drew a map, which was in fact the map route they took. Now, Mr. Tucker, the defendant, for his part, tried to point out, well, of course he would know that. He was there. But the prosecutor tried to use it as showing corroboration. Because, look, his statement is more valid because this piece of his confession is true. That's not how corroboration works. That is absolutely not how corroboration works in a technical sense. Corroboration in a technical sense is evidence that exists outside the co-conspirators. Something you can point to, literally anything. Now, the co-conspirator can certainly bring it to your attention. For example, he wore this shirt on the day of the thing, but then you need something that ties him to that shirt. Like literally anything would be nice. We found the shirt in his dresser drawers. Someone can testify to him wearing it. We have video of him wearing it. Like literally anything. We found the victim's blood on the shirt. Any of these things would be great. But yeah, they don't have corroboration. So I'm confused as why the prosecutor brought it in the first place. But apparently they thought it was a good case to bring because, well, 11-1 to be guilty. So I guess there's that. On Thursday, the prosecutor sought to reinstate a gag order, which would prohibit Tucker and attorneys from discussing the case outside the courtroom. Jones told Mansfield to relax, and he needed to take some time about reinstating the order, saying it's no time to get rash. I don't know what the point of a gag order would be at this point. The point of a gag order is to prevent the evidence that you have from coming out other than through the trial, because there are rules of evidence and stuff. But, we've already had the trial. So I'm not sure what the point is at this point, but okay. Mansfield responded that someone had leaked his cell phone number, and he received 11 death threats on his phone. Don't do the death threats. He called the media's attention before and during the case a media blitz, which, yes, we have a lot of attention on this case. We probably wouldn't have as much attention on the case had it not been pro se. So I suppose if the goal was to get attention to the case, mission accomplished. But please, for the love of all that's holy, please let an attorney do it. I'll do it. I'll do it for cost. I'll come down there. He already apparently has lawyers that he works with, so I can get them to help me. Presumably they'll help me pro se because they're more familiar with the case. But I'll do it. I'll take a lead. I'm sure they'll get me pro hoc vice. I don't have a Florida bar number, so I'll have to get permission, but I'd imagine I can get permission. His other lawyers will probably back me if it's what it needs for Mr. Tucker to do it. So I just need cost. Please pay for my hotel room and, my transportation and my food and stuff. I'll do it. It can't get any worse, man. It can't get any worse. Tucker, who represented himself and took the stand during the trial and told the jury there's no DNA evidence tying him to the murder, which there isn't, and the prosecutor tried to use the term inconclusive to mean it's confirmed. Well, it's inconclusive DNA, so it could be his DNA. And once again, a defense attorney would point out, yeah, that's not how that works. The state has the burden of proof. So inconclusive automatically means no. But okay, yeah. So, yeah. Tucker never objected to any piece of evidence, he told the jurors. Well, that's not quite true. He did object to some Facebook stuff, but for the most part. Mr. Tucker, the defendant, saying, my story has not changed in 6 years and I didn't take a deal, he told the jury. He sure did. And that seems to be true. From evidence, incidentally, the prosecution itself elicited that he'd been making consistent statements, which seemed odd. They probably won't make that mistake again in the next trial, I'd imagine. They don't have me on video. They don't have physical evidence. There's no forensic evidence. Don't believe the prosecutor. Don't believe the words. Look at the evidence. Yeah, apparently, again, the jury was 11-1 to convict. And, juries are human beings. Let's just boil it down. Juries are human beings. And they're going to look at this emotionally because most people are emotional by their nature. Most people are driven by emotions. That isn't a bad thing. It's just the way people are. They have a feeling in their gut, and they'll use their analyticals to confirm their feeling rather than being analytical in nature. So you have to show the jury a reason why to rule for you. And Mr. Tucker's greatest weakness is, although he's presenting good information, he presents it in a rambling and incoherent way that makes it very difficult to literally hear it. It makes it difficult to literally hear it. So, as I was talking about with Mr. Tucker, there's a science of listener attention kind of thing. So public speakers know this, especially the ones who've studied public speaking and rhetoric. But they know that there's things that you need to do, especially in a prepared remark, to be able to make it easier for people to follow you. And one of those things is flow. So that things flow. It makes it easier to follow a story. Movies flow. Most movies flow. Movies that don't flow and that jump around are hard to follow. Movies that are chronological or otherwise present a story arc are easier to follow. And people like things that are just easy to follow. Mr. Tucker presents evidence, but he presents it in a jumbled way that in a literal sense makes it difficult for people to hear him, because people are so thrown off from the disconnect of what happened before to what happened now. It makes their mind work too hard, and it literally makes it difficult for them to hear it. So that's Mr. Tucker's greatest problem. And one of the reasons he needs a lawyer, or at least a good person who knows rhetoric, to be able to present his remarks in a rhetorically sound method. And I don't think that problem is fixable by Mr. Tucker, because Mr. Tucker is kind of baked into his speech patterns, and he certainly doesn't have training in rhetoric to be able to defeat that, and we can't get it fast enough. So I wouldn't expect the next trial to be any different in that regard, and he has a real problem there. The jury heard Belmont's tape deposition from nearly 4 years ago, in which she said Tucker was not involved in the robbery or murder. So we have a deposition from one of the victims who says, yeah, this person was not involved. The deposition was taken because of Belmont's failing health, and in the event she could not testify in the position. In the deposition, Belmont implicates Wilson and says Tucker's voice and body type were different from that person who was Wilson when she was attacked and robbed. Initially could not identify the individual. She couldn't identify him. But after time, she was like, no, this isn't the person. Apparently what the prosecutor did not want to hear. Before it rested, the prosecution called a DNA expert who said on the stand that DNA taken from the knife and other evidence could not be proven. At best, it was inconclusive. See, again, this is the kind of thing that an attorney would hammer. We'd really hammer what inconclusive means. And be like, what that means you can't determine it. Right? And then one of the things I was thinking about is how I would go about to illustrate this. I might say, all right, so if we took blood from one of the people in this courtroom and tested it, is it possible it would come up as an inconclusive? Is that possible? If they say yes, and I would hopefully know the answer to that question before I asked it. If the answer to that question is yes, then like I've made my case. Because then I can be, don't you remember how he says possible? I do that during closing, right? I was like, don't you remember how he said it was possible we could take someone's blood from the courtroom and be inconclusive? That would mean that one of you, the jurors' blood could be taken and be inconclusive. That would mean one of the judge's blood could be taken and be inconclusive. So how good is inconclusive? Were you there? I don't think so, but your blood would still come off inconclusive. So inconclusive doesn't mean anything. Therefore, you should dismiss it. QED, right? In closing statements, Mansfield reminded the jury that Johnson testified in the case, that Tucker was part of the robbery and was carrying the knife when Tucker, Wilson, and Johnson left to rob Bonnet and Belmonte. Yes, Johnson did testify to that, but Johnson is a co-conspirator who is looking to make a deal to not get life in prison. And he got 5 years. So he has some incentives to say it was somebody else. Johnson had been the prosecution's main witness in the case, and also he vacillated wildly, which is another way of saying lying. Even on the stand, he was inconsistent in his statements. Again, a lawyer would have been able to make that more apparent. And also, probably, if I had to bet, he'll be less vacillating on the stand the next time around. He'll learn from his mistakes too. Then you can impeach him using his prior testimony, but then, of course, you need a lawyer that knows how to do that. So, yeah. Johnson served roughly 4 years in jail and was given time served for the murder robbery. That looks like a lot of incentive. Johnson testified he drove Tucker and Wilson to the scene of the crime, but did not participate. So he's like, I was in the car, I was the getaway driver. Tucker and Wilson were the ones that did the assaults. But the witness who was stabbed is like, no, it wasn't Tucker. You would think that would be enough. But 11-1 to convict. Again, because Mr. Tucker does not present it in a coherent fashion. This isn't to slight Mr. Tucker, by the way. It's just not a strength of his. We all have weaknesses. It's okay to have weaknesses. And it's okay to admit that you have weaknesses. I'm not trying to slight Mr. Tucker by saying that he rambles or is not able to present a cohesive narrative. That's not a slight on him. It's simply not one of his strengths. I'm sure that he's good at things I'm not good at. He's lived a different life than me. He probably has skills I don't have. I've never put up tarps on roofs in Florida after a hurricane, for example. So he has skills I don't have. He has training I don't have. But you just have to admit your weaknesses. You know, if you want a tarp put up, Mr. Tucker might be your guy. If you want a cohesive narrative, Mr. Tucker's probably not your guy. Hopefully Mr. Tucker will recognize that before it's too late. Because he should be able to win this case. Mr. Tucker is of the view that the judge and prosecutor are corrupt. This conclusion I'm not willing to draw because it would take quite a lot for me to be able to draw that conclusion. But even assuming the premise, the jury is still a jury. They're a jury of 12 people off the street, as it were. They have to be convinced at the end of the day. And even if you assume, again, which is a premise I can't validate, but even if you assume every ruling by the judge was wrong, as it relates to the exclusion of evidence or objections or otherwise, even if you assume every decision by the judge was wrong, a competent attorney should still be able to win this case, even with that deck. Because the prosecution's deck sucks so hard that even with all these disadvantages, a competent attorney should be able to win the case. Because there's nothing here. There's nothing here. And you can only put up so much smoke, man. You can only put up so much smoke. I can win this purely without, I could theoretically win this even without putting on a case as the defense. I could do it just by cross-examining them and pointing out they don't have anything. You know, so I can win this. A competent attorney can win this. Hopefully Mr. Tucker will find a competent attorney. He has apparently competent attorneys, by the way, because his wife is uber rich. She was a co-founder of CrossFit and apparently sold her shares for something like $8 million. So it's not a lack of money problem. Apparently he has 2 attorneys who have been advising him in the background, including a former U.S. attorney who would be available to step into this case at a moment's notice because, you know, they are very familiar with the case, having dealt with it in all the prelims and stuff. So, yeah. But, you know, I think anyone could step into the case at this point. Any lawyer could do it because, especially to the degree you have other lawyers who are more familiar and can brief you, any lawyer should be able to step into this case and be able to just go. You know, wife is worth 20 million. Yeah, whatever the number is, it's a lot. So maybe it's 8 million, maybe it's 20 million. What's the difference? What's the difference of $12 million between friends? It doesn't matter. The point still stands. So, yeah. Either way, she has money. Either way, she has money to afford lawyers. Johnson, for his part, testified that 3 men planned the robbery and Wilson and Tucker put on dark clothing prior to robbing Belmonte and the murder of Bonnet. Johnson said he drove Tucker and Johnson to the Treehouse, a stock island building known for drug activity, which apparently, although I haven't found a picture of it, and maybe at the end of the stream we'll try to find one because this sounds hilarious. But apparently this is a multi-story balcony thing that's been built on top of an RV, which apparently includes individual apartments that was put together by some guy, somehow, some way, and people live there. So apparently it's a party den, drug den, apartment building thing that just exists in Key West. Sounds exciting. Sounds exciting. Okay. But of course, none of this is relevant to whether or not he did the crimes, of course, as the prosecution tried to say many things that were completely irrelevant. Isn't it true that you lived in a treehouse that's illegitimate and that it's a flop house? Yeah, I suppose, but why does anyone care? It doesn't matter. But the prosecution is just trying to make it look like he's an irresponsible person, or he's a degenerate or a vagrant or something, which means he's guilty of the murder somehow? I don't think so, ma'am. But apparently the jury was eating it up 11-1. The jury was eating it up. Johnson drove off before Tucker and Wilson could get into the truck. Tucker and Wilson allegedly met at the warehouse where the three was living at the time. Tucker eventually gave Johnson $50 for taking them over the building known as the Treehouse, according to Johnson, which is not corroboration. Unless you have the $50 that has, Tucker's fingerprints on it or something, or DNA on something. But yeah, that's not corroboration. Where is the $50? It's probably been spent long ago. So it's not corroboration. You don't have any corroboration. Johnson, who's admitted to having drug and alcohol addiction, has been charged with murder and robbery, but pled guilty to felony charges of robbery with a weapon while masked and aggravated battery. And how about time served? He has a lot of incentives. I agree with you, JPC. Tucker must drop the corruption issue. Keep your eye focused on the ball, right? That's one of the things we preach here as we're doing legal analysis. Keep your eye focused on the ball, especially to the extent you can't prove it. So making an allegation like the whole system is corrupt without evidence to back that up makes you seem unhinged. It makes you seem like a wild guy with an unclear mind. It makes you seem like you're not a reliable person either. You can't just make up stuff. You can't just make up things. You have to keep your eye focused on the ball. Now, if you had actual proof of corruption, if you could actually prove it, then fine. But if you can't prove it, you don't introduce it to a jury, because credibility is everything, or close to it anyway. And you don't argue what you can't prove, or at least present substantial evidence there too. So, if I were his lawyer, I wouldn't be arguing corruption. First of all, I don't need to. Second of all, I seriously doubt there's any evidence that would allow me to make that argument to the jury. And third of all, it's almost certainly irrelevant anyway. So yeah, I wouldn't make that argument. I don't have to make that argument to win. And making that argument makes me look not credible to the jury. So maybe that's why Mr. Tucker wants to represent himself, because he really wants to present this. It's to his detriment, though. It's to his detriment. It's not relevant. It makes you look bad. It's incoherent, literally, because he can't present it in a coherent fashion. It's literally incoherent. And all kinds of other problems. But if Mr. Tucker insists on this evidence being presented, I suppose we'll have to go pro se, because I don't think any reasonable lawyer would do it. I wouldn't do it. It wouldn't be to his advantage. I don't have to do it to win. My objective as his lawyer is to, if I were his lawyer, which I'm obviously not, also not barred in Florida, so I'd have to get permission and pro hoc and all the rest of it. But if I were his lawyer, my objective is very clear. The goal is to win for my client to the extent I can, right? The client sets the goal. The lawyer sets the means to the goal. The client says, how about not guilty? I, as the lawyer, get to choose how to go about that. I get to choose what witnesses to call. I get to choose what questions to ask. I get to make those choices in furtherance of the objective. And different lawyers would go about it in different ways. They'd ask different questions and have different strategies. So I'm not saying that my ideas are best ideas. I'm not making that claim at all. But I think you would be hard-pressed to find an attorney who would go with the conspiracy theory, because there's not evidence to back that up. Yeah. Yeah. And also, even if I could, I think it's probably off point and not the right time to bring up the issue. Maybe a different time. Belmont did testify from the hospital bed, but because she was making comments outside what was being asked, Jones told the jury to strike her entire testimony. Also, apparently, she had been given some sort of medication that might have influenced her ability to testify. So there was some dispute about exactly what the medication was, but she was given potentially some sort of medication which interfered with her ability to testify, which also is pretty dirty pool. And as a lawyer, I would have objected and said, let's do this some other time when she's not under medication. And if the prosecution's like, well, we need to move, I'm like, well, that's a you problem. So, there's that. Most damning in her testimony was telling the jurors the prosecution's main witness, Johnson, not Tucker, was one of the two men who attacked and robbed her and stabbed her. Because remember, the other person, the Tyrone or whatever his name is, which I keep forgetting his name, I apologize, but whatever his name is, said he was the getaway driver. Remember? So there were two attackers. She says there were two attackers. So if it isn't, Travis, that was his name, Travis. If it isn't Travis, because Travis is in the car, then it must be Tucker. But she says it wasn't Tucker. And she says that she knows that for certainty. She wasn't able to say that at the time. She was only able to determine that later. But man, oh man, I mean, yeah, I'll drive that point home until it goes boring. Another comment that was stricken but could have weighed heavily in the minds of juries was a statement that Tucker made in closing argument. He told the jury to ask why the former lead detective in the case was not present. Yeah, you can't ask that question because you yourself have the right to call witnesses, right? So you can't. He was attempting to comment on like, well, if the state wanted to prove its case, it would have called person X. You can't do that. You can't do that because you have the right to call person X. So if person X is important to you, you can call them. So you can't comment on their absence because you have the ability to make them present. So you can't comment on your absence, right? You can't force an error and then comment on the error. So of course you can't do that. That's illegal. But he tried anyway. Phelps was later fired from the sheriff's office for using racially charged language during the murder investigation when speaking with another detective, and also because apparently something like 11 different investigations she was involved with had problems. She wasn't a very good detective. So all those problems. So yeah. So those are the things. So I hope Mr. Tucker will see this message, and I hope he'll listen to me. I really have no motivation here other than to help him in his case because I don't believe the state has it. I'm a legal analyst. So I don't believe the state has it. My only incentive here is to make sure that he doesn't get convicted because the state can't prove it. The state, of course, has the burden to prove it. We all know that. They have the affirmative obligation to prove beyond a reasonable doubt. But 11-1 to convict shows you what that means in the real world. 11-1 to convict shows you that means the rest of the world. The fact that you're at the defense table is already one strike against you. And, 3 strikes, you're out, as it were. So, the witness, the testimony of Travis, I suppose, is strike 2. And 11-1 to convict. And again, it's not necessarily even that the defense has to prove it. Because again, as I sort of said, I think the defense could win this without calling anyone. Although, why would you? Because you would absolutely want to call the victim who says, yeah, it wasn't your guy. Because she was, she would have incentives to know the truth. So you'd absolutely want to call that person because of course you would. And there's probably some other people you might want to call for other reasons. But what you really need at the end of the day is just someone to be able to present the cohesive narrative. He wasn't cohesive in his opening. His opening wasn't bad. His opening wasn't bad, but it wasn't organized. And his closing certainly was not organized. His closing was very rambly and disorganized. He didn't know how to do the things he needed to do. So yeah, all that stuff. 11-1 to convict is what the media is saying. 11-1 to convict. So, one person was willing to stand there and not get him a life sentence. But again, I don't really think it matters, as I sort of said. I don't think it matters because, again, the ice cream murder trials was 11-1 to acquit. And then the next jury was like, how about 12-0 to convict? So I'm not really sure it matters either way. But either way, I'll believe it. I'll believe it's 11-1 to convict. I'll believe it. Mr. Tucker apparently doesn't want to believe it in his continuing belief that somehow, he can win this. But I don't know if he needs a slap across the face or something. I don't know. Maybe someone needs to go down there and slap him in the face. I don't know. But yeah. But if he wants someone, I'll do it for cost. It's going to cost me something to go down there, and I'm not a rich man, so I'll need my expenses paid for. I'll need the hotel room paid for. I promise not to jack it up by going 4-star or anything. Just a normal competent hotel will be fine. I don't need anything particularly fancy. Just something that's quiet. So I'm going to need at least a medium scale hotel, so it's not in the sketchy parts of town where there might be lots of noises, because I'm going to need my beauty sleep. So just a basic $200 a night hotel will be fine. We don't need to go too extravagant on this. $200 a night will be fine. And I need my expenses paid for going down there and getting back. And I need, any scores, of course, any costs as it might relate to evidence and production of evidence and copies and stuff. And I'll need my per diem so I can eat. But I'm willing to do it for cost, especially if he has other lawyers who are there who will help me, because lawyers who are more familiar with the case and can bring me up to speed and also help write my motions for me, because that would be nice, because they're more familiar with it and they can help write my motions that I need and act faster for me. They can be second chair. It's fine. We'll make it work. And of course, again, I'm not a Florida lawyer. I'm not barred in Florida. So I would need the court's permission. But I'm in good standing in 2 different states. And so as long, I would imagine if it came down to it, that his lawyers who are in an advisory role would prefer me with them as second chair to Mr. Tucker. So I probably would not be their attorney's first choice, I would imagine. But if it's what Mr. Tucker wants, if it's the only way to do this thing, I'll do it. And I'll have the other attorneys there, and we can work on it together, and it'll be fine. My only trials to date have been like a landlord-tenant matter. So going straight to the murders is one hell of a jump. But if it's what it takes, I'll do it for cost. Do I want an untrained legal aid? Hey, Tony, you can come down there too. And we can also get Matt. We can also get our friend from Botanic, Matt. We can get Matt to come down there. He's a lawyer now, but he doesn't have an ABA license, so he can't practice. But he can come down. He can hang out with us. I'm not sure if he can sit at counsel's table or not, but he can come chill with us. Yeah. Do we think not guilty because of what's known outside the jury's hearing? We think not guilty because we don't think the state has it. That's why we think it, or at least why I think it. I shouldn't speak for all of us. But yeah, for me, this is really, really simple. This is really incredibly simple for me. The state has the burden. This is what it comes down to. This is easy. The state has the burden of proof. At least in principle, they're supposed to have proof beyond a reasonable doubt. I don't think they do. Therefore, I can only draw one conclusion. He's not guilty. That's how the logic works, right? He's presumed innocent. Not guilty is the status quo. So he is not guilty until he's guilty. So until the state can change the status quo, he is in fact not guilty. So he's not guilty because the state doesn't have it. It's really that simple. Yeah. They don't got it. I don't think they got anything close to it. 11 jurors apparently disagree with me, but I think 11 jurors disagree with me in substantive part because Mr. Tucker is just not able to present the information in a coherent fashion. Again, no slight to Mr. Tucker. I'm sure he's great at other things. I'm not saying he's not a good person, incidentally. Also, incidentally, I'm also not saying that you have to think he's a good person. You also may not trust him with your dog. You may very well think he's a con artist. You may very well think that he is unreliable. You may very well think that he's into some strange things that you would not want to be involved with. You may very well want to keep him far away from you because he's at best a bad influence. But I just don't care. I just don't care. You can also think he's a conspiracy theorist, and I just don't care. Because he thinks, apparently from his own arguments, he thinks the system writ large is a conspiracy. He thinks that there's this massive conspiracy against him, which may be true. It may not be true. You may think he's a conspiracy theorist. You may think he's QAnon. I literally don't care. I just don't care. For me, this is just super simple. It's really easy. It's really super easy. Super easy, barely an inconvenience, guys. Super easy, barely an inconvenience. The state has the burden of proof to prove beyond a reasonable doubt. It is the state's affirmative obligation to show that the defendant did these crimes, not other crimes, not other things, not he lives in a flop house, not he's a little cray-cray maybe around the edges. Okay? None of these things. It's the state's burden to prove he did this thing. The default is not guilty. The state doesn't have it. Ergo, he is not guilty. It's that simple. I don't have to know whether or not he did it. I don't care. The state can't prove it. Maybe he did it. I just don't care. I just don't care because he's not guilty because the state can't prove it. It's just that simple. It's just that simple. Yeah. Who decides if there's enough evidence to bring it to court? Well, the prosecutor and judge do, but it's a fairly low burden because it's probable cause. And Mr. Travis's Mr. Travis is his name, is Johnson, but everyone calls him Travis, so I'll call him Travis. If I call him Mr. Travis, you'll forgive me. Travis is enough to have probable cause. I mean, the statement of, well, actually it depends because in New York, well, it would be a probable cause to arrest, but in New York, it would not be probable cause to charge because they split the difference. At least that's the law as it used to be, and I don't think there was a change on that. You would actually need cooperation. You can't use the uncorroborated testimony of a co-conspirator in New York. You need something, literally anything. Literally a thing. So in New York, I don't think you could arrest the guy. You have probable cause to arrest. But in New York, I'm not even sure you have probable cause to try because normally those are the same thing. But in New York, those are different things. So yeah, I'm going to assume that there's probable cause for the moment, but they don't have proof beyond a reasonable doubt. Really, I think there should have been a directed verdict by the judge, to be quite honest. I don't think they have it. I don't think they have anything close to having it. I simply do not believe, I do not believe a reasonable jury. Okay, if he had been convicted, I would not feel foolish for making a sufficiency of the evidence argument. Now, that is a really fucking hard argument to win. I know it's a really fucking hard argument to win. You should know it's a really fucking hard argument to win. Because the jury is the finder of fact. And as we sort of say, it's up to the jury to weigh the evidence, and it's up for them to choose how much to believe a witness or not. They can believe a witness a little bit, in whole, in part, or any combination. They can believe a big lie doesn't matter, and they can believe a little lie does matter. Because they're the jury, they're the finder of fact. They can choose the weight, the importance of it, right? So when you're making a sufficiency of the evidence argument, you're basically trying to say that no reasonable jury could possibly weigh this evidence in any combination that would be reasonable in any sense to get to guilt. Now, if that sounds like a really fucking hard argument to win on appeal, you'd be correct. But I wouldn't feel foolish for making the argument. I wouldn't feel foolish for making the argument. I may very well get my teeth kicked in by the Court of Appeals, but I wouldn't feel foolish. You know, I wouldn't feel foolish because I think the case is that thin. So yeah. Let me put your chats back up on screen, by the way, because I put them off for a while because I was doing something else. Rob says you can talk yourself into a conviction. 100%. 100% you can talk yourself into a conviction, no doubt. And between his rambling nature, between the fact that he is a somewhat, what would you say? How would you say this in a way that isn't unduly character assassination? He is a okay, he lives in a flop house, you know, and he does do drugs, and he lives with other people who do drugs and other crimes and all kinds of shit. He is a somewhat disreputable person. Is that fair without it being unduly charged? Can I say that? So he's a somewhat disreputable free spirit. There you go. How about that? That's more charitable. He's a free spirit. Yeah, let's go with that. So he's a free spirit, somewhat rambly. He has somewhat grandiose claims about grand conspiracies to which he can't even begin to prove and are irrelevant to the case at hand. You know, if you're going to go into court and be like, yeah, the big Bubba system is against me, not a great position to work from, you know? So you see, this person does drugs. He does fireballs. He lives in a flop house. He hangs out with unsortly people. So, you know, he's at best one step from being a vagrant. You know, so the jury looks at him and it's like, you know, this person is not who we expect to be. And for better or worse, that feeling, that conclusion reads on to the guilt, which it shouldn't, but it does. Because jurors are people. Remember, they're reasonable, they're people. And they're like, yeah, he probably did it. And for a jury, that's often good enough. So, you know, he needs someone to help present his case. He needs someone to be like, okay, this stuff doesn't matter. And a lot of that's where closing would be. And a lot in closing, you'd be like, the prosecution brought up a lot of things that don't matter. You know, they brought up about the fact he lives in a flop house. That doesn't mean he's a murderer. They brought up the fact that, you know, he thinks there's a big Bubba system. That doesn't make him a murderer either. None of these things make him a murderer. You know, I'd actually literally say in close. It's like, you may not like Mr. Tucker. You may not think that he is a reputable individual. Well, I'd probably say free spirit because that sounds better. Yeah, free spirit is better than reputable. You might think he's a free spirit person. Perhaps he's not the kind of person that you would choose to hang out with. And he hangs out with other people that are free spirit. Perhaps you wouldn't choose to hang out with them, but that doesn't make him a murderer. You know? So you need someone who can actually present that in a coherent way. And of course, if I were doing it for real, you know, I would have written out my close long ago. Right? And I would have memorized the goddamn thing. So I didn't have to read from it. I would have it there in case I lost my place or something. But, you know, I would try to give it from memory. And I can cram a speech into my mind with enough practice. I used to do it all the time for public speaking. I used to cram 20-minute speeches into my head. I mean, it takes a lot of repetition to be able to do that. But yeah, I can do it. I can cram a 40-minute speech in my head if I try hard enough, I'm sure. All you do is you say it to yourself over and 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 over, and then you got it. It's like what something like an actor might do, you know? Or at least that's the way I do it. I used to I used to walk up and down the halls at my work, and I would basically do this pacing thing where I just do these laps around the hall, because I could do a lap inside the building I worked in, and I would just be muttering to myself. Basically, I'd just be like talking to myself. I basically looked like a crazy person. If I'm out on the street, I'm out on the street doing this, right? Just walking around sort of methodically with like my head bobbing and like all these gesticulations. It looks like the works of a crazy person, right? If you're on the street, you like see this person muttering. It looks like a complete incompetent, but yeah, that worked for me. So hey, what could you do? Yeah, what can you do? Oh no. Okay, I have to figure out how to Google this thing so that I can find it. Treehouse murder, because I want to see a picture of this thing. Oh yeah. Okay, so here's a picture. Let me see if I can find some other pictures of this thing because this looks good. Open link in new tab. I don't want to open the link. I just want to open the picture in a new tab. Open image in a new tab. Okay, there we go. All right, can I find other pictures of this thing? Yep. Let's see what else we got. I want to see pictures of this thing. All right. Okay. Is this? No, that's not it. Well, I found apparently 2 pictures of it. Murder. Treehouse murder. Key West. No. See if I can find any other pictures of this thing. Give me a second as I Google image search. All right. I think I found 2 images that are it, so we'll just do with that. All right. So here apparently is an image of the tree house, I guess. And here is a picture, I think, of the same thing. Maybe. I mean, it was in the article. I don't know. You sent me a couple of emails? Cool. Let's see what we can do. Let's see what the emails have for us. I'm looking. Give it. Calm down. I'm calm down. I'm working on it. Is Jules here? Good morning, Jules. It's nice to have you here. Yeah. So here apparently is another. Okay. So here's a picture. So okay. Can I? Okay. That looks cool. All right. So here apparently is another picture of the treehouse. I guess. How do we know these are the numbers? It's what's reported in the press. How does the press know it? I don't know. Presumably they talked to one of the jurors and one of the jurors said that was what the numbers are, I would guess. I mean, I don't know that for sure, but that would be the most likely conclusion. The press says it, and how would the press know it? They talked to one of the jurors. So, I mean, I would think. And here apparently is, here is another image. That's not really a great image. Let's see if I can do anything better to make this work better. Come on. Yeah, that's not really a good image. It's too small. Okay, and then we have this one we saw earlier is another picture apparently of the treehouse. Press says Mansfield said it. Well, how would Mansfield know? Because I don't believe I don't believe they're allowed to talk to the jury unless the jury talked to them. which, as I suppose, is also possible. One of the jurors approached him. So that's possible too. Carol C in chat says, I'm just seeing this. He has an air of criminal. I would have convicted him. Too many stories change. Well, Carol C, with all possible respect, whether he has an air of criminality about him, even assuming that's true, is not sufficient to convict, and I hope that you would know better. Right? And even if he's a criminal in other respects, it's not enough. You have to have proof beyond a reasonable doubt that he committed this particular crime. And even if his story has changed, which I don't think it has, incidentally, because even the prosecutor noted he's had the same story since he told the police about it 6 years ago, which was a mistake by the prosecutor. I'm sure they won't make again. But even if he had changed the story, that isn't enough. You have to find proof from the state side. So voting to convict is a mistake. It's using some sort of general perception of the person's character to conclude that he did this particular crime, which is not what you're supposed to do. His character is his character is valid insofar as his trustworthiness, but the state just doesn't have it. That's the state doesn't have it. So even if you don't believe Mr. Tucker, which you don't have to believe him, although he told the same story to the police 6 years ago, so he's been pretty consistent. But even if you don't believe him, the state doesn't have it. It's not enough. So I really hope you wouldn't convict. That's not the way this is supposed to go. But, Carol C may unfortunately represent the perception of many jurors. I don't think Carol C's statement is not valid insofar as it reflects what many jurors in fact think. We give them all the instructions in the world about what they're supposed to do. But I think the way that Carol C perceives this is unfortunately emblematic of the way many jurors really go about this. And one of the reasons you need an attorney who can present the evidence in a way that makes people like Carol C see a better version of things. There really was no proof. The only proof we had was the statements from Travis. That's the only proof we have is statements from Travis. And Travis has a lot of incentives to lie. And Travis was vacillating on the stand. He's not reliable. He's telling a whole bunch of different stories. Travis is all over the place. He was all over the place during the trial. Travis isn't reliable. And even if he was reliable, there's still no corroboration in a technical sense. So, again, Florida doesn't seem to require that. I'm just noting. $5 years is a massive incentive to lie, no doubt, especially when it's already time served. It was time served. He had already been in jail 4 years, so it was actually 4 years. So it was time served, so he didn't have to serve any additional time. He had already done it. So how about I get out of jail now versus how about I stay in jail forever is a lot of incentive. Jury know about Travis's plea deal? Yes, they would know about it. But you really need someone to hammer that home in a better way. You need someone to really bring that out and bring it out at closing and really point out these things. Zachariah Anderson was pretty much convicted on character. Yeah, I think that's unfortunately true. I think the trial lawyers know that's true. And Barnes has said as much, and I think Barnes is basically right. If they think it's more likely than not, even based on perceptions of you're just a bad guy, I think that's the real world. So yeah, I think it's one of the many reasons. I think it's one of the many reasons that, as a general proposition, lawyers don't like lawyers sitting on cases, because lawyers sitting on cases actually apply the law, and it's not what they want them to do. It happens more in DC and in Northern Virginia because there's so many lawyers. It's kind of hard to avoid. But as a general proposition, yeah, you don't want lawyers on because they're not as manipulatable. For me, this is a solid not guilty. Do not pass go. I don't even have to think about it. It's like I can't even get past. I can't even get past more likely than not. I'm barely above. I'm barely above suspicious. Hope you're doing well today, Jules. Hope everything is going well in your life. We do like seeing you happy. I really, really hope that he'll get a lawyer next time. It doesn't have to be me. It probably shouldn't be me. He has a former U.S. attorney. That would probably be a much better pick. But I'm just saying, if it comes down to it, I have not read that the gag order's back on. I don't know that the gag order's back on. I don't know that. And if it is, it doesn't really make sense to me, but okay. If I was on the jury, I think he's guilty because he wouldn't shut up. If you're not guilty, there isn't much to say. Oof. Let the state speak and don't reply if they don't have evidence. Oof. Okay. I don't know how to respond to that. If he was innocent, he'd just sit there. Seems like an odd thing to say, but okay. What else can I answer for you before we run off the stream? There won't be a gag order without a hearing. I don't know if that's true or not, but either way, it doesn't make much sense to me. Yeah. A guy with the same time personality thought his arrogance and long windedness was annoying, but doesn't make him a murderer? Exactly so. Would I recommend he focus more on proving not guilty? Well, I wouldn't put it that way because I don't have to prove anything. But I would definitely make it more obvious that the state hasn't met its burden. And yeah, I wouldn't argue corruption because it doesn't matter and I can't prove it anyway. I can't imagine a reasonable lawyer. Well, there are a lot of lawyers, so I shouldn't say that, but I don't really think a reasonable lawyer would be well advised to go in and talk about corruption. First of all, because you don't have to, right? That's the kind of argument you make when you got nothing left. That's the kind of argument you make when you have nothing left, right? So the evidence against my client is so great. Like, well, what else can I do? It's like, well, maybe I'll talk about corruption and see if I can get anywhere with that. So that's the kind of argument you make when you don't have anything else. You don't make that argument here because you have a lot else to work with. Can you get a new judge? Probably not. I wouldn't anticipate it. And it makes you look tinfoily. Yeah, exactly so. When am I going to do another Supreme Court Reacts? When I have time. Right now, we're stuck in the Crumbly trial, so we're a little bit stuck at the moment. Is Kurt still practicing law? No, not the moment. I've been on a 1.5-year hiatus. I'm doing a little bit of consulting work, but not much. But I've been on a 1.5-year hiatus. And then I need to figure out how to get back into law, how to get back in somewhere else, somewhere different. Can you get a change of venue? No. I don't see how. I don't. Yeah, almost certainly not. Would I argue corruption if I could prove it? Maybe. Maybe. I need a lot, but I would imagine the other side would object to relevance and probably win anyway. because it doesn't strictly speaking lead to his culpability. It is strictly speaking not a fact that makes his guilt more or less likely, unless I can show how the corruption actually manifested with respect to a particular piece of evidence in the case. But I couldn't just do it generally. So if I could show, like, I don't know, that the lab was corrupt somehow, and therefore the DNA results are bad, but the DNA results say inconclusive anyway, so why do I need to? So unless I could show how the corruption manifested with respect to a particular piece of evidence, it's probably irrelevant. And I wouldn't be allowed to argue it anyway. So probably not. How would I get around his testimony in the stand? What do you mean? His testimony in the stand is completely consistent with his story. I don't have to get around anything. I don't have to get around anything. What do you mean get around his testimony? His testimony is good for us. Is it hard to return being a lawyer? It's sometimes hard to change practice areas as a lawyer. It's sometimes hard to jump from one kind of law to another. Because all my experience, if I want to jump to a different field of law, is not useful or not as useful. So I basically have to start out at square one. And, you know, a firm is more likely going to want to hire someone just fresh out of law school than me because, well, they have a lot more years to work with them and stuff like that. So it's tough. Is there time for a motion to represent him? Sure, absolutely, no problem. Yeah, absolutely no problem. He has plenty of time. His alibi being drunk and sleeping and can't remember was his testimony? Yeah, well, I can make that work. I can make that work. It would mean like entry level. It would be like an entry level job somewhere. Big law wouldn't hire me. Not that I'd necessarily want to work for big law. It's not my thing. Big law, by the way, is just an informal term that speaks to law firms that are particularly large, like over 100 lawyers or something like that. And they tend to be a little pressure cookery and not quite my shtick. What area of law would I change to? I'd like to do appeals. I think that'd be fun. Maybe I could get a Florida bar license and join Gosney in the appellate division. That could be good. I suppose I could apply for the public defender's office as an appellate lawyer. Although criminal appeals are really, really hard for a whole bunch of reasons. So I don't know if that's my shtick either. What about doing my own law practice and advertising? Possibly. Yeah, put up a shingle, as it were. Do a one-man show. Maybe. Why do I want to change the area of law I was doing? I'm just no longer interested in doing it. I find it too tedious. The patent law by its nature is very precise and very exacting. It is what I used to do is patent law, and patent law is very, very precise in a lot of ways. It really matters what words you use and exactly how you say things. So it can be very, very tedious, very pedantic. I just don't want to do it anymore. It pays really well, though. It pays exceptionally well. So there's that. I could try to go to a firm. They probably paid me more than I was being paid before. Probably get hired at like $150,000 to start, which would be nice. But I just don't know that I want to do it anymore. You know, I'd rather get paid $60,000 to do something I actually enjoy than get paid $150,000 to do something I used to do, you know? You change career 3 times, it's doable? Cool. Well, I'll work into it. All right, guys, I'm going to sign off for now. I hope you enjoyed the stream. I've been on Civil Law, and until later, my friends, I hope all's well. Cheers, my friends, and goodbye.